In this video, I will show you what a defendant can do in patent infringement cases in Germany after the complaint is filed. In the previous video, I gave you some general remarks and tips about the overall procedure and the hearings and the different deadlines. So if you want to know more about that and tips, general tips about patent infringement in Germany, then go to the previous video. So first of all, you can ask for security of costs for non-EU plaintiffs. So that can be very efficient. If the plaintiff cannot deliver this security, then the whole case is moot. You can also immediately acknowledge all claims of the plaintiff if the plaintiff did not warn you or send a cease and desist letter, because then the costs of the overall proceedings will be shifted to the plaintiff. Of course, you can challenge the validity of the patent with opposition proceedings or revocation actions before the Federal Patent Court. That can be very efficient. The German system is bifurcated, so sometimes the infringement court will stay the proceedings until there is a decision in the revocation action. One other strategy is about making the judges limit the scope of the claims to basically the drawing or the example given in the patent. You have to know that some judges are coloring the features in a claim and then in a depiction of the infringing good and marking the features in the infringing good with corresponding colors. But what you can do is you can get a drawing from the patent where the features are shown and color them in the corresponding colors of the colors that are used in the claim for the various features. And sometimes the court will use these drawings to interpret the claims, and then naturally sometimes the interpretation of the claims will be very narrow, so that can help you as well. One other defense that I want to mention is the Formstein defense. If you are working within the prior art, you cannot literally infringe a patent. That has been decided by the Federal Court of Justice in Germany a long time ago. So if you find yourself working in the prior art, you find a good piece of prior art that exactly describes what you are doing, then maybe you can defend yourself with the Formstein defense. Then another strategy is to find good arguments to move the argument from literal infringement to infringement under the doctrine of equivalence, because that way you will have a lot more room for arguments to avoid a favorable decision for the plaintiff. If you like this video, hit like, subscribe to my channel, and most importantly, protect your intellectual property and go make it count.